So good afternoon, ladies and gentlemen. Welcome back to the first plenary sessions. I'm Johannes Chan of the Faculty of Law of this University of Hong Kong. And once again, let me welcome everyone to come to this ICONS conference and to our universities. I hope every one of you have a refreshing cup of coffee. We have a wonderful start and wonderful speeches from our Chief Justice and from Lord Neuberger. And we now move to the first plenary sessions. We have three very eminent speakers. Closest to me on the stage is Judge Navi Pillay, Commissioner for the International Commission Against the Death Penalty, as well as former United Nations High Commissioner for Human Rights. In the middle is Professor Yash, Ghai, my former colleague at this university, now Emeritus Professor, as well as Director of Katiba Institute of Kenya. And then at the farthest of the panel is Professor Eva Brems of the University of Ghent, also the founder of his Human Rights Center. So without further ado, and as we are running against a very tight time schedule, let me first invite Judge Pillay. Let's welcome Judge Pillay.
Good afternoon, everyone. I'd like to begin by thanking ICONS for inviting me to join this distinguished audience. It's a real privilege. Diversity, identity, and human rights, our subject, encompass the entire spectrum of primary dimensions of all individuals, everywhere, including race, class, caste, ethnicity, gender, age, religion, disabilities, sexual orientation, language, culture, poverty, educational background, experience, attitudes, and personality. And the subject covers respect for the rights of various people, indigenous peoples, migrants, asylum seekers, displaced people, women and children, LGBTI communities, minorities, and all persons who are discriminated against, who are disadvantaged, exploited, or tortured, whether by society in general, by governments, or institutions. So that's a full range, but I will obviously limit myself to focusing just on some issues. Let me say that in May last month, I was in courtroom 600, in my capacity as President of the Advisory Council of the Nuremberg Principles Academy. And we were in this courtroom 600 where the Nazis had been tried to participate in a conference on the Tokyo Military Tribunal, which apparently had never been done before, a discussion on this Tokyo Military Tribunal. And by the way, you see in those courts, the American prosecutors prosecuted the Japanese generals for waterboarding, which they said is such a terrible form of torture. And today it's become respectable in the United States. But my point in mentioning courtroom 600 is that this historic setting once again brought home to me how ruthlessly the notion of a pure race, of xenophobia based on racial and religious bigotry can be weaponized and result in mass atrocities. So out of the ashes of the two World Wars rose the United Nations Charter and the Universal Declaration of Human Rights, setting clear standards of equality, freedom from discrimination, and human dignity for all persons. You know, as a South African, I lived through the dark years of apartheid in my country where the law was bad. I was convinced during this time as a lawyer of the need to be guided by a rule of law based on universally recognized standards of what is right and just. The UN Universal Declaration of Human Rights is such a foundational framework for human rights, and today all countries of the world subscribe to its principles. It is the most translated document in the world. Most laws and constitutions embody the principles, and all religions of the world embrace these rights. Human rights violations are among the root causes of every type of instability and conflict, which means that every state has an interest in detecting gaps in its laws and practices that hinder the protection and promotion of human rights. Every country has a vital interest in defending a principled structure for a common set of global values. People want respect for all their human rights, civil and political, economic, social, and cultural rights. They want both freedom from fear and freedom from want. In a world where the rich are getting super rich and the poor really poor, there is an acute need for states to end poverty and inequality. Discrimination in all its forms is anathema to the concept of respect for diversity, and yet they are constant companions. The way to combat discrimination is to promote respect for diversity. There is a road to perpetration of human rights violations and crimes, and hate speech, particularly by political leaders, is on that road. Violent attacks based on race, religion, or ethnicity, such as anti-Semitism and Islamophobia, are not unconnected to the surge of extremism that we are seeing today. We are living in times when communications between political leaders and the public through online and offline media has become critical. Many of the statements made by political leaders in the USA and Europe in support of restrictions against migrants, asylum seekers, and immigrants, such as that Muslims are terrorists, immigrants are taking away the jobs of locals, Mexicans are rapists, and Africans are violent criminals, all of which bear little relationship to the truth. Yet most people are unaware of the reality and unable to separate fact from fiction. The false propaganda fuels the fears and anxieties of people and engenders suspicion of the other, suspicion of difference. You are no doubt familiar with President Trump's tweets. During his 2016 primary season debate, he resorted to demonization of a whole group. The US, he said, I quote, should hit the kin of enemy fighters. You have to take out their families when you get these terrorists. You have to take out their families. Don't tell me torture doesn't work. Torture works. Okay, folks? I think we should go much stronger than waterboarding. They're chopping off heads, believe me. We should go much stronger. So the utterances of Trump and emerging right-wing leaders in Europe are extremely concerning for human rights and for the international rule of law. In response to the Trump travel ban against Muslims, the American Society of International Law and many other institutions have done this, have publicly reconfirmed their commitment to, I quote the American Society of International Law statement, committed to the value of openness, tolerance, and the free and lawful movement of persons and the free exchange of ideas that are essential to the establishment and maintenance of international relations on the basis of law and justice. The dehumanization of victims underpins every occurrence of atrocity crimes and is favored as an effective strategy by perpetrators of mass crimes. In Darfur, and you know that's where the Sudanese leader al-Bashir is, as alleged in the ICC indictment, fully in control of the military, of the militia, the Janjaweed. This Janjaweed carried out genocidal attacks against black South Africans while chanting, I quote, "You make this place dirty. We are here to clean this place. You blacks are like monkeys. You are not human. In the Rwandan trials, the genocide trials that were held by the International Criminal Tribunal for Rwanda, on which I served as a judge, we listened to evidence of radio broadcasts from RTLM radio inciting the killing of members of the Tutsi ethnic group. So it was clear to us that had it not been for this radio station pouring out the messages, the genocidal attacks would not have spread across the country. And this is what the radio station blasted out. Look at the person's height and his physical appearance. Just look at his small nose and break it. The Tutsi were widely referred to as incontania, meaning cockroaches, by the political and military leaders who incited the population to participate in the genocide of the Tutsis. Witnesses who appeared before us testified that, I quote, hate speech was spilled like little drops of petrol that soon spread like fire across the country. So in the ICTR media case of Nahimana and others on which I presided, we convicted and sentenced to life imprisonment the 3 founders and controllers of RTLM radio and the editor of Kangura newspaper for direct and public incitement to commit genocide and crimes against humanity. So although they had not attacked a single person with the machete, did not kill anyone, they are all serving life imprisonment because the hate speech amounted to a crime at that level. Now, of course, we all understand that freedom of expression is a crucial right. Some of us fought with our lives for this right, including Nelson Mandela in my country. And the right to freedom of speech must be promoted to safeguard diversity, to safeguard identity and human rights. However, we said in our judgment, and you know it, we said it's not an absolute right. It comes with responsibility. Article 7 of UDHR provides that all are entitled to equal protection against discrimination and against any incitement to discrimination. And Article 19.3 of the International Covenant on Civil and Political Rights allows for restrictions provided by law and, where necessary, for the rights of others and public order. And Article 20 of the Covenant provides that speech may be restricted in cases of any advocacy of national, racial, or religious hatred that amounts to incitement to discrimination, hostility, and violence. And of course, the United States, that claims to be the most speech protective, has a reservation on this provision. They will not permit any law restricting freedom of speech. So, of course, it's very difficult to regulate limitations in the way of restricting speech and very difficult to change attitudes. I share the concern of all judges and lawyers when the executive interferes with this fundamental right. In fact, when we delivered the Nahimana judgment, before we delivered it and spelt out the facts and the law very clearly, before that there was a great deal of anxiety, particularly on my continent in Africa, that repressive governments may use this judgment to stifle speech. So, as Professor Gregory S. Gordon of the Chinese University in Hong Kong has said in his book, in regulating human decency, the law's writ is circumscribed. It cannot legislate civic grace or decorum. It cannot enjoin hatred, but it still has a role to play in regulating verbal conduct that helps foment the most unspeakable crimes. We need laws to protect freedom of speech as a fundamental right. We also need restrictions against robust hate speech for the protection of the rights of vulnerable minorities and for the promotion of respect for diversity. Political debate, dissent, and opinions must be protected, as expressions of free speech necessary for democratic functioning. And regrettably, and we tracked this when I was High Commissioner for Human Rights, that country after country is following the Russian law on restricting the activities of NGOs, restricting them from receiving outside funding and support. Many civil society organizations, human rights defenders, journalists, and political opponents continue to operate in an increasingly hostile environment under laws that stifle dissent. Civil society actors, as we all know, have an important role to play in demanding implementation of human rights and accountability for violations. By spreading awareness of human rights through research, studies, and court cases, NGOs, academics, lawyers, and the media provide a powerful and essential stimulus for social change and justice. And therefore, protecting them for their rule of law work is a prerequisite for the protection of human rights and democracy. So while we have to address provocative, insightful speech, we have to respect the fundamental principle of freedom of speech. Respect for diversity is particularly needed in the world of migrants, asylum seekers, and refugees. An alarming tendency of what is being called the migration crisis in the United States and Europe is the xenophobia, the inhuman rejection, the suspicion, and the aggressive pushback of human beings. We are all appalled at the drownings at sea, the use of high-powered water hoses, detention behind fences and in prisons, including of women and children. Reports reach us of children being detained, even though this violates the Convention on the Rights of the Child. And we all know the back and forth on the separation and forcible detention of children in the United States under Trump's migration policy. And yesterday he announced that he would like to remove the judges and courts' oversight over migration issues. So really, honestly, we don't have to wait 100 years to see barbarism creeping in. We're seeing it now. And that's why discussions such as this are so important. Suspicion, stigmatization, and xenophobic violence directed against those who look different or speak their own language or practice their own culture and religion occur in many countries, not only in Europe. In my own country, in South Africa, despite a good constitution and a Bill of Rights designed to protect the rights of all persons within the country, cycles of xenophobic violence against foreign African nationals continue to erupt with seeming impunity. Hundreds of thousands of men, women, and children are making hazardous journeys across deserts and across high seas at great risk and trauma, fleeing for their lives. They have no choice but to flee when their homes are shelled, when their cities are under siege, or they're about to be killed. They are fleeing from crossfire, conflict and persecution, natural disasters, hunger, deprivation, and they're fleeing from discrimination. It stands to reason that where people have food and water and shelter and safe from falling bombs, they have security, education, jobs, freedom, and hope, they are not likely to take the risk of exposing their families to dangerous crossings, to detention, and to an uncertain and hostile environment. In other words, human rights violations of persecution, unrelenting poverty, and environmental degradation compel migration. So we must challenge assumptions underlying the rejection of migrants by upholding human rights values codified in the international human rights law and international humanitarian law, in refugee law and the law of the sea. These have been around for some time, proudly embraced by societies. they are as relevant during crisis as they are in peacetime. In fact, more so. So what are some of the misunderstandings and the unfounded misperceptions underlying suspicion of migrants? One is that the push factors of conflict, droughts, floods, and deprivation are among the burdens of the countries of origin and are not the concern of receiving states. That migrants are terrorists and security risks. That migrants cooperate with smugglers, armed groups, and traffickers. That if we stop rescuing migrants at sea, they will stop coming, and if we close our borders, they will go away. That there are sufficient legal channels open to migrants to apply for entry. Not true. The reality is that this is not an option for refugees fleeing in their thousands like the Rohingya, or for low-skilled persons, mainly from developing countries. Refugees are often unable to access fair and effective asylum channels. In the same vein, harsh border controls and law enforcement measures lead to them falling prey to smugglers and to traffickers. So the only effective way to manage migration crisis is to follow the principles of human rights that have proved the test of time and have grounded societies in inclusiveness and respect for diversity. Just to name some of these principles that I'm talking about. One, international law requires rescue of migrants at sea. Two, the right to individual screening and determination of status under the Refugee Convention. Third, no one should be subjected to prolonged or arbitrary detention, discriminatory or arbitrary decision-making, deprivation of humane conditions, and respect for privacy and dignity. Children must not be separated from their parents and certainly must not be placed in detention. The principle of refoulement must be respected. Special protections should be provided for vulnerable groups such as disabilities, the elderly, pregnant women, sick and wounded persons, and those at risk of continuing persecution by hostile groups. So these are the principles that are grounded in respect for diversity. States have sovereign authority over the border, true. But this power carries the obligation to protect every human being found at its borders. It should not exercise its authority at the expense of ignoring international obligations such as being free from exclusion, denying asylum altogether, or curtailing migration at any cost. Respect for human rights, respect for diversity are also the tools to combat discrimination on the basis of race, disabilities, indigenous peoples, women and gender rights, LGBTI persons, labor rights. The list is long. If I may just refer to some of these aspects. On race, the Human Rights Council held its annual debate in March this year, focusing on promoting tolerance, inclusion, and unity and respect for diversity in the context of combating racial discrimination. And they noted with concern that racial discrimination and xenophobia was on the rise, and that the international community should prioritize the fight against intolerance and do so within the framework of the Durban Declaration and Programme of Action, as well as the 2030 Agenda for Sustainable Development. Now, with regard to people with disabilities, the committee established under their convention is now served by commissioners with various degrees of disability. Every commissioner has some form of disability. And so they proudly assert their function under the slogan, "Nothing about us without us." We have advanced a long way in respecting the diverse needs and aspirations of persons with disabilities, but we still have a long way to go in terms of implementation. For instance, there's no wheelchair access to this wonderful hall. Briefly then about indigenous peoples and minority. Indigenous peoples are often victims of discrimination and exclusion and are among the poorest in many countries. I had occasion, they wanted an outsider to come and speak in Malaysia on their program of affirmative action for the Malays, which has been going on for 40 years. And I compared it with our system of affirmative action in South Africa, which has been going on for 20 years. Now, in Malaysia, it's supposed to benefit the Malay community, the poor Malay community. In South Africa, it was meant to benefit the poor amongst the black population, the majority population. Instead, in both cases, the programs benefit the least discriminated amongst those focus groups, so that in both cases and many other parts of the world, these kind of programs end up in benefiting the elite and those persons who are close to the political leaders. So we really need to think about how best to advantage the traditionally disadvantaged who are being discriminated and whose rights are not respected. Why? Because of the violation of the principle of respect for diversity. They're just seen as different because they are poor. Women, as well, fall into this category of people who have been traditionally discriminated. We heard from the keynote address by Judge Neuenberger about some of the benefits that the UK has distributed under colonialism, about these old laws. Yeah, there was the one law which allowed the husband to beat his wife as long as the rod was no thicker than the thumb. That's why you get rule of the thumb. So we have to examine some of these old colonial measures, some of these traditional attitudes that have gone unchanged. Now, whether in conflict or in peacetime, human rights violations based on deep-rooted gender inequality and far-reaching discrimination against women are a constant reality. There is a need to identify discriminatory laws and practices, eliminate de jure discrimination against women, and adopt measures to end violence and sexual violence against women, and to see that their civil, political, economic, social, and cultural rights are respected. Now, with LGBTI people, I have said it is not easy for decades of prejudice and intolerance to disappear by the stroke of the legislator's pen. But change towards respect for human rights for all must be made. After all, we address discrimination and ill treatment of sufferers of, say, leprosy, or left-handed persons, and persons with mental illness. It is our task to move beyond the debate on whether all human beings have rights, for such questions have long been raised to rest by the UDHR, and instead we should aim to secure the climate for implementation. So those who are LGBT, transgender, transsexual, or intersex are full and equal members of the human family and are entitled to be treated as such. No human being should be subject to discrimination, violence, criminal sanctions, or abuse simply because of their perceived sexual orientation or gender identity. You know, I included this in my remarks because for 70 years, the LGBTI community failed to have their issue addressed in any agenda in the UN fora. And I put it there, even though I was criticized heavily for trying to introduce what they said, new standards that are not universally accepted. So that came in terms of criticism from country. And I said the Universal Declaration of Human Rights applies to everyone. It doesn't say except LGBTI people. And do you support discrimination and violence against LGBTI people, I said. So that was my entry point to have this issue addressed and research done in the United Nations. So I don't have much time. Diversity in the workplace is a very important concept. I know of many departments within the UN who are now looking into how best to address the question of why certain people are excluded from jobs, and they're trying to identify the factors that are making minorities less likely to enter or succeed within the organization. And we did research that indicate that when recognized and valued, diversity in the workplace enhances individual productivity, organizational effectiveness, and sustained competitiveness. So if that's the case, why has respect for diversity in the workplace not been addressed? So let me conclude to say the protection and promotion of human rights and respect for diversity is best served by developing independent, pluralistic, and harmonious civil societies, and through human rights education, have an independent judiciary, and to create a safe and an enabling environment. State agents, including military and law enforcement officials, as well as political and religious leaders, should be sensitized to advocate for tolerance and dialogue. Measures should be taken to counter hate speech, racism, and discrimination. Thank you very much for your attention.
Thank you, Judge Pillay, for sharing your thoughts on some of the contemporary issues, some of which are pretty gloomy. But it's a time for concern, but it's also a time for challenge. And the judge could be very assuring that wheelchair access to this hall is indeed provided through the two entrances at the front of this hall. May I now invite our second speakers, Professor Yash Ghai, who will speak on diversity, identity, and human rights. Let's welcome Professor Yash Ghai.
Well, I too want to thank ICONS and the University of Hong Kong for the invitation to be here and to speak. In this important and complicated subject, I can only skim on the surface, starting with diversity. Diversity of peoples is a result of a variety of factors, including, if you go back to history, culture, traditions, religion, language, citizenship, being minorities, tribes, migrants, refugees, and perhaps what used to be the most common, conquering or being conquered. Diversity, often assumed to be a new phenomenon, in fact goes back a long time in history, even before the days of slavery. In historically more recent times, one can think of the Europeans capturing and settling within the lands of indigenous inhabitants of the Americas and Australia, and later Asia and Africa. The acts of annexation introduced diversity of different kinds within these lands, bringing together indigenous peoples of different races, religions, and languages, producing within each new territory communities of different languages, religions, color, etc., but more importantly, a new ruling class controlling the bulk of the people and snatching their resources. In my own country, Kenya, it brought together neighboring people of over 50 languages, numerous religions, and forms of livelihood by the British, apart from Europeans, Indians, and Arabs from faraway places. But I assume that our interest today is in contemporary times, the large number of people who have moved to other countries for better economic lives, or worse, escape from oppression in their homeland. In some instances, the state may encourage foreign communities to settle in its jurisdiction because it needs their labor, their talent and experience, and sometimes indeed out of compassion, as with the refugees. Diversity has caused both great anxiety and resentment to all parties. At the root of it is a strong sense of unfairness, sometimes exploitation, and generally of the loss of homeland, and with that often the sense of their identity. And now let me move on to identity, which does not necessarily have a common understanding. Charles Taylor, a distinguished Canadian philosopher, used to define identity as a person's understanding of who they are, of their fundamental characteristics as a human being. Identity in this case is achieved through a person's search for his or her inner soul. Another point he used to make is that there is a certain way of being that is my way. I am called upon to live my life in this way. If I am not true to myself, I miss the point of my life. According to him, this consciousness of the uniqueness of one's identity is a result of the breakdown of social hierarchies which had defined our roles and gave us the understanding of our place in society. But with democracy and the reordering of society, our identity comes from self-reflection and contemplation. Identity has become essential to the sense of our own dignity as an attribute of being human. Thus, dignity is closely related to equality. Others, like Kimlicka, also a Canadian, and many other people now, I suspect, regard identity as the way we negotiate values and make choices, and comes from our membership of a cultural community. Thus, in their different ways, Taylor and Kimlicka place the individuals securely within a cultural context and interactions within a community. Identity in many countries including my own country, seems to be becoming important to a person merely because of connections with their tribe, regardless of its values, an approach very different from that of Taylor. In this sense where identity is a matter of a tribe, a collective matter robs the concept of any value or personality. This consequence for Kenya and indeed other African states has become extremely negative for our national identity. A number of countries in Asia and Africa, and my remit was to speak about these two continents, have tried to make a distinction between religion, language, history as part of the culture of the people from nationality or nationalism, a matter for the state. In other words, there is a great variety of languages, histories in many countries in Africa, Asia, but there is also, or there should be also, a sense of unity belonging to the same state, same country, with a common future. Unfortunately for many countries, this identity serves the purpose of defining for whom to vote. In order to understand the logic of this, we have to understand their perception of the state as a source of wealth for their community and themselves. Identity is more a matter of political mobilization than a precise delineation of a community's characteristics or beliefs. Ethnicity has become a way of dealing and bargaining with the state. The distinguished political science scholar Crawford Young has warned the unlimited brutalities which can ensue when the bonds of comity dissolve are a powerful reminder of the importance of the ongoing search for community transcending ethnic differences. On the other hand, there is an invocation of nationalism for different objectives. A community's entitlements may depend on how it and others perceive it. A self-conscious ethnic group can place itself in different categories deriving from political science or legal discourse. It can be a cultural, religious, or linguistic group, or it can be a minority, or a nation, or a people, or indigenous peoples. They are in part derived from political theory or practice, such as a nation with a clear notion of the right to self-determination, including separatism or secession, or a minority or indigenous peoples which derives more from legal norms or rules, for example, Article 27 of the ICCPR, or the Declaration on the Rights of Minorities, or the ILO Conventions on Indigenous Peoples. Perhaps the most significant of these are the concept of nation and indigenous peoples, as they carry a large or high set of entitlements. To this extent, a community's self-definition is determined or at least influenced by international political or legal norms, and sometimes the characterization or classification under national law, as indeed Spain did not long ago. I'm now going to turn to human rights, and I examine that in the context of Asia and Africa, but really about India as an example of developments in human rights developments in Asia and South Africa for the African continent, but if there is time, say a little bit about my own country, Kenya. To go to India, one would say that it's one of the world's most complex countries, with all major religions, numerous linguistic groups, strong regional affiliations, complicated social structures, and great social disparities. Successive Indian requests that, no, I won't get into that because of time, but I begin with the period of independence where India tried to find its own way forward. It paid from very early time great attention to a Bill of Rights, which gives everyone a sense of their dignity and equal treatment by the state. They realize that a Bill of Rights has to accommodate cultural diversity, take care of minorities, eradicate poverty, and accommodate very big diversities, deal with hierarchical relationships that were very much part of India, and promote national unity and integration. Far from these factors being regarded as obstacles to rights, rights were deemed essential to deal with these social and political problems. Indians justified rights on the principle that all powers of government, executive and judicial, are derived from the people. Indian leaders were very conscious of the poverty of masses. They had to reconcile rights directed towards maintaining the status quo, particularly property rights, with those directed towards social change and justice. Conscious of the oppression that inhered in social and economic structures, such as untouchability or caste, they were committed to empowering the disadvantaged groups. This suggested some restrictions on liberal rights of property or equality, and an activist state engaged in the distribution of resources and the direction of the economy. The constitution makers wanted to bring about social reform, especially among the Hindus. This required prohibiting socio-religious practices deeply embedded in civil society, which would only be done by extending, at least partially, the regime of rights to private conduct, transcending public-private distinctions. They were committed to protecting minorities, though after the partition of India with Pakistan, they wanted to avoid forms of entrenchment which might promote fresh demands of separatism. They were more generally conscious of the cultural diversity of India and the need to fit rights within that diversity. At the same time, they were preoccupied by the imperative of nation building, cultivation of a common identity and common loyalties, especially as they were driving the Constitution or drawing the Constitution at a time when the country was being torn asunder with horrendous problems of security, lawlessness, and communal carnage. To an extent, these opposing objectives were balanced by adopting the device of the enforceable Bill of Rights, but not exclusively civil and political rights, and a non-justiciable Charter of Directive Principles for measures of social and economic equality, where the necessary social and economic reforms could only be achieved by qualifying civil or political rights, such as those of equality and property. This was clearly stated in the Bill of Rights, and authority or obligation for remedial action laid down accordingly. I want to say a little bit about religion and minority rights in India. Many provisions of the Constitution balance universality with particularity, cultural or religious autonomy with common citizenship. The Constitution seeks to hold an even hand between different religions and to establish a modernistic approach to public life by establishing a secular state. No person can be compelled to pay any taxes, the proceeds of which are specifically appropriated for payment to promote or maintenance of any particular religion or religious denomination. No religious instruction may be provided in educational institutions funded or recognized by the Constitution. And there can be no, and nor could people, no, I'm a bit confused here, so So let me just go on. On the other side, Indian secularism is less thoroughgoing than that of the US. On the one hand, the state is authorized to regulate, even ban, practices associated with religion. On the other hand, there is recognition of the profound influence of religion on the people and the general support of religious organizations. Understandably, many provisions deal with minority rights. Since religion was a primary source of division and conflict, there are several provisions for the protection of religious belief and practices. All religious groups are entitled to set up institutions to their own property and to manage their religious affairs. Minorities have the right to conserve their languages, script, and culture, and to establish their own educational facilities. However, there are limits to the autonomy of minorities, particularly religious minorities, on the ground that uniform laws were necessary for a modern state and for cementing national unity. This was met with considerable resistance from Muslim leaders in and out of the Constituent Assembly. The compromise was the codification and modernization of the personal laws of Hindus and associated communities, but for the most part, the Sharia has continued to govern the personal lives of Muslims, not without contention, both among Muslim communities themselves and as between rather aggressive Hinduism and traditional Muslim leaders. So far as tribal people are concerned, the authority to make laws on succession to chieftaincy, the inheritance of property, marriage and divorce, and social customs is vested in their own district or regional councils. A major theme of constitutional discourse is the balance between guarantees of formal equality and fairness for groups that have been historically disadvantaged. That includes what they call caste and scheduled tribes. I now have to jump over a great deal so that I can deal with the African dimension of balancing national interests when there is such a diversity of languages and religions and so on. And here I want to speak about South Africa. In early 1990s, apartheid collapsed with its own weight of inequity and internal resistance and external pressure. With the demise of the apartheid regime, South Africans embarked upon the task of fashioning a new constitutional order. It was clear that the debates on rights and negotiations on the terms for inclusion in the Constitution would be the central issue. There had been no Bill of Rights until then. The apartheid regime was based on repression of rights of the non-white people. The South African state was organized on a massive racial categorization of people with unequal citizenship and unequal rights. The campaign against apartheid was based on rights and democracy rather than opposition to whites as such. The African National Congress had declared its commitment to non-racialism and rights as early in the 1950s. The South African National Congress had done so in the 1920s. The supporters of apartheid, who spurned rights for others, now began to see the virtues of rights and the new dispensation of democracy. I again have to jump over many of my points because I have a note here from my friend that I should wind up now. None of these approaches that were pursued in South Africa, there was a distinct emphasis on cultural differences, now talking of the apartheid period, and the great, I think, achievement of the struggle against apartheid and the establishment of non-racial South Africa is, I think, extremely uplifting. I just want to mention one or two types of rights which were, of course, everything was novel in terms of rights in South Africa. The right to equality, prohibiting discrimination on various grounds, also includes in its definition full and equal enjoyment of all rights and freedoms, and authorizes legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination. There was a big plan to make up for past injustices. I would like finally to say that the importance of cultural rights in South Africa now, the Constitution provides for the creation of a commission for promotion and protection of the rights of cultural, religious, linguistic communities, a gesture toward traditional leaders and toward some of the right-wing white sections of the population. The institution, status, and role of traditional leadership, according to customary law, are recognized subject to the Constitution, and the application of customary law is permitted so long as it is consistent with the Constitution and relevant legislation. It is thus clear that the exercise of the cultural rights is always subject to general norms of the Constitution, including human rights. Insofar as customary law is concerned, this represents a singular victory for African women whose position under such law is normally inferior to that of men. And finally, the success of South Africa in moving from apartheid to a democratic regime has been widely admired. One reason for that success lay, no doubt, in the moral approach to questions of power and justice, which undermined the framework of human rights before. So I have a few more things to say, but you're also going to hear a very distinguished speaker, and I will therefore just thank you for your attention. Thank you.
Thank you, Yash, Ghai. May I now invite our third speaker, Professor Eva Brems, who will talk about multicultural human rights conflicts. Eva, please. Excuse me.
Yeah. Good afternoon. I prepared this small PowerPoint presentation for you. It's very simple, and its only purpose really is to facilitate you tuning back in should your jet lag cause you to involuntarily tune out. So, in this distinguished panel, I think that I'm licensed and expected to bring a European perspective. Indeed, issues of diversity and identity are extremely topical in Europe. They determine political fault lines, They fill judicial dockets, and they are the subject of intense scholarly debate. In this talk, I conceptualize multicultural conflicts as human rights conflicts, that is to say, conflicts about the acceptability of restrictions of minority rights. I keep my examples close to home, but I think the issues have broader relevance also beyond Europe. Across Europe, many similar multicultural conflicts arise, similar on the facts, most notably in the confrontation of majority Christian/secular societies with Muslim minorities, and similar on the law, as rights provisions do not diverge that much across Europe. Yet, in different countries, different positions are taken on similar issues, such as the circumcision of boys, religious dress and symbols, or religious slaughter of animals. What's more, across Europe, solutions to multicultural conflicts do not seem stable. They are the subject of constant pressure and renegotiation. From a legal perspective, part of the reason for this is that the main supranational body addressing such issues in Europe, the European Court of Human Rights, adopts a hands-off approach to multicultural conflicts. In particular, when it comes to religious accommodation claims, it deliberately grants a wide margin of appreciation to national authorities. At a deeper level, this reveals an underlying lack of common ground in any single society, as well as on the European level, about the meaning of concepts such as inclusion, integration and neutrality, and about the implications of human rights such as non-discrimination and religious freedom. What human rights law requires in any particular multicultural conflict is deeply contested. The net result is that human rights law offers little guidance in this field. And of course, we have to keep talking about substantive human rights-based solutions. But the claim in this talk today is that in addition to talking about outcomes and substantive rights, we also need to talk about process and procedural rights. I submit that there are at least 6 reasons why we need to talk about process in multicultural human rights conflicts, and these approach the matters from different angles, from principle to strategic. The first reason is rooted in minority experience. All too frequently, on top of the restriction of minority rights, additional injustice is caused by the way in which this is done. For example, when the Flemish and Walloon regions in Belgium recently banned unstunned religious slaughter of animals, the Muslim and Jewish communities suffered not only from a restriction in the exercise of their religion, but also from the absence of prior dialogue, as was the case in Wallonia, or the shallow nature of such dialogue, as was the case in Flanders. The feelings of exclusion and injustice they experience are caused by the combination of the substance of the decision and the process that led to its adoption. The second reason is related to developments in the case law of the European Court of Human Rights. As mentioned, the Court is set on a course of light scrutiny in this field. Yet, at the same time, in some other areas of its case law, there is an interesting development towards scrutiny of domestic processes. This implies that serious procedural defects can lead to a finding of a violation regardless of a wide domestic margin of appreciation on the substance. And I'm not in favor of a wide margin of appreciation in these cases, but in the current context, it is likely to stay. While thorough substantive scrutiny in such cases remains something to strive for, a more realistic and also important goal is that the court would systematically apply robust procedural scrutiny in minority rights cases. The third argument relates to the reality of domestic courts in some countries. When intolerance for minority practices is a mainstream attitude, and when in addition there is a judicial tradition to steer away from anything that resembles policy making, the result is a very high threshold for courts to rule against public opinion and against political will in favor of an unpopular minority. Judges may feel on unsafe ground, interpreting hotly debated key concepts in one way rather than another, which may be seen as taking sides in the ideological conflict. Procedure, on the other hand, is quintessentially legal matter, and therefore a lot more comfortable terrain for courts. A court that upholds an evidence requirement, for instance, is not likely to face a claim that it is overstepping its mandate. The idea that procedure is in a way neutral terrain is linked also to the fourth argument. When key concepts such as neutrality, inclusion, living together and such are strongly contested, they arguably lose their power to fulfill the crucial role of human rights analysis in this field, which is distinguishing between justifiable restrictions of rights and unacceptable expressions of anti-minority bias. In a context that is saturated with anti-minority bias, this is a difficult task. Reliance on respect of fair procedures is of great assistance in preventing bias seeping in and in unpacking it where it occurs. Finally, two reasons for valuing procedural fairness in general have particular salience in the context of multicultural conflicts. The first of these is the logic of process efficacy, the classical instrumental reason for valuing the quality of process conceives of good process as a way to bring about good outcomes. And a good outcome in human rights terms is, of course, an outcome that respects, protects, and fulfills human rights. But remember the starting point that what human rights require in any particular multicultural conflict is deeply contested. In such a context, arguably, it is even more important to believe that good process will bring about good outcomes. And the last one is the beneficial impact of procedural fairness as revealed by empirical research in social psychology. A vast body of research shows that in their fairness assessments of authorities and the law, people attach more importance to procedural fairness than to distributive fairness. In other words, the way people are treated by judges and other authorities is more relevant to them than the particular outcome in their case or the policy decision taken. This research has shown substantial impact of procedural fairness on perceptions of institutional legitimacy as well as on outcome compliance, individual well-being, and social cohesion. It is very important to realize these beneficial impacts for minority members. Yet it is equally important for members of the dominant majority who may feel threatened or left out in the face of vast societal change of which increasing diversity is a part. It's inherent in multicultural conflict that minorities as well as majorities will win some cases and lose others. An emphasis on procedural fairness can contribute to avoiding that the losses will lead to individual alienation, contestation of institutions, and loss of social cohesion. For all these reasons, decision makers need to pay particular attention to procedural fairness in multicultural conflicts. In addition, the European Court of Human Rights should set procedural fairness standards in this field and should supervise their respect. Now, procedural fairness is a broad concept. This is about transparency, equality of arms, independence and impartiality. It's also about time and many other things. Today, I highlight two procedural elements that I consider crucial in the context of multicultural conflicts. These are evidence and voice. First, evidence. Even before the terms fact-free politics and alternative facts came into our lives, politics did not necessarily match well with evidence-based reasoning. In legal reasoning, on the other hand, evidence requirements are of the essence, and yet one frequently observes in multicultural conflicts that courts accept government claims about the need for restrictions of minorities' cultural or religious expressions without requiring authorities to prove such claims. Even the European Court of Human Rights has often gone along with this tendency. Examples can be found in its case law on bans of religious symbols. Some of these bans are motivated by arguments of public safety. Without much scrutiny, the court has accepted that safety requires all of the following: the removal of religious headgear during security checks and during physical education classes, the replacement of a Sikh turban with a helmet when driving a motorcycle, the removal of a Christian cross by a nurse during work, and a bareheaded photo on a driver's license. All these claims can be at least contested empirically, but nevertheless they were accepted as if they were a matter of common sense. Another common rationale for religious dress restrictions is that of protecting individuals against pressure that would threaten their freedom of conscience. In Strasbourg, this argument justified headscarf bans for Turkish university students and Swiss primary school teachers without any need for these governments to prove their claims. Yet, these arguments can in fact be empirically verified, and such verification is arguably crucial in performing the critical function of distinguishing bona fide proportionate restrictions of religious freedom from unjustifiable harassment of minorities. In addition, an analysis of the court's case law in this field of religious dress restrictions shows that when the court has rejected a government claim, this was often linked to reasoning requiring evidence that the interest invoked by the state was indeed threatened by the wearing of religious dress. And on the other hand, in the cases, most cases, in which no violation was found, the court seemed content to accept a theoretical link between the religious dress in question and the interest that the restriction sought to protect. In multicultural conflicts, evidence requirements are an essential tool for unpacking anti-minority bias, and since such bias is an unfortunate reality, it is not surprising that a serious effort to uncover bias leads to findings in favor of minorities. The other procedural element I want to emphasize is voice or participation. This is a key procedural value from the social psychology angle. It represents the need of people to be able to express their own perspective and to feel that their views are genuinely considered. The absence of voice is a source of major frustration and generates a strong sense of injustice. And yet it is a disturbingly frequent phenomenon in multicultural conflicts. A striking example was the introduction in France and Belgium of criminal bans on face covering in public, targeting the Islamic face veil. In both countries, face veil wearers were a tiny minority, and policymakers knew almost nothing about them. They made all kinds of assumptions about these women, yet did not show any interest in their point of view. In France, the ban was preceded by the work of a committee that heard evidence from 211 persons, yet they did not plan on hearing a single face veil wearer. In the end, they heard one who insisted very much to be heard. The Commission obliged her then to uncover her face during the hearing and summarized that hearing in 10 lines in the 658-page report. The European Court of Human Rights not only upheld this ban, it justified its finding, amongst others, with a reference to the democratic process that had taken place in France, thus sanctioning a procedure that left the women concerned without voice. You know, when human rights are applied outside the field of the law, in the so-called human rights-based approaches to development, education, health, etc., they are synthesized in a number of key principles. And invariably, one of these principles is participation. Yet, the right to participation is not as such recognized as a general human right. There is a right to participate in one's trial, a right to take part in the conduct of public affairs as well, but no general human right to have a voice in procedures leading to decisions that particularly affect one's life. International human rights law does emphasize participation rights for specific groups. This appears to be the case when there's a suspicion that certain people's voices may, under standard conditions, be disregarded, or that certain measures may have a differentiated effect on certain categories of people. Thus, the right to have a voice in decision-making procedures that affect oneself is recognized for children in the Children's Rights Convention and for indigenous peoples in ILO Convention 169. On minority rights in general, the Council of Europe Framework Convention stipulates in its Article 15 the obligation to create the conditions necessary for the effective participation of minority members. And one of the measures that are promoted under this heading is consultation regarding legislation or administrative measures likely to affect them directly. Similar ideas are included in many soft law texts of human rights, including the Human Rights Committee's general comment on Article 27 of the ICCPR. And of course, I fully support this formulation of participation rights for minorities, but I also note that it does not seem to have taken firm root yet in government practice or judicial reasoning. Then what I think should be non-negotiable, I should specify, is a lot more narrow. That is to say, voice in matters that risk affecting minority human rights. I conclude, my main claim today is a modest one. This paper is not presenting the solution to multicultural conflicts. Instead, what I submit is that procedural fairness should be part of our human rights framing of such conflicts and hence part of the sustainable solutions we strive for. Thank you.
Thank you, Professor Brent. We have 2 minutes for question and answers. And since we have started 10 minutes late, if I may just extend it by just about 5 minutes and just take 1 or 2 questions from the floor. If anyone has any burning questions, yes, the one gentleman in the middle. Could someone pass the mic? Please keep your questions concise.
Thank you. For Judge Pillay, thank you for your presentation. It seems to me that we're commemorating the 70th anniversary of the Universal Declaration, as you said, widely translated document. And we have a very prominent and complex legal architecture on human rights, yet never before did we see what we are witnessing today all around the world, as you have said. How do we bridge the gap between that legal architecture of norms that we have on the one hand and the practice in which we are just witnessing the retrenchment and the pushback and the backlash against human rights institutions? What are the solutions? What's the way forward for the next 70 years? Has the language of human rights become unintelligible in the face of massive gross and human rights violations that we were just not prepared to witness? Thank you.
Thank you. If I may just take 1 more question. Anyone has any questions? Yes, the gentleman at the back.
Thank you. Thank you very much. Eva Brems from Oxford University. I want to pick up on a point that was made by Professor Brems, but I'm open the question to all panelists. What do you think about the justification for deviation from human rights standards based on democracy concerns that have been applied by the ECHR, for example? What is a constructive way to go around the trump card of we have a democratic legitimation for this type of policy, the majority wants it, and therefore this is something that we must comply with, and human rights just go out of the picture? Isn't the idea of human rights adjudication very much linked to judicial review, which allows for scrutinizing decisions by the majority?
Thank you. If I may ask the panelists to reply, you have each 1 minute. Yes.
Thank you for your question. It's very important. You know, wherever I've spoken, this is what young people are asking. What's the point in having this wonderful framework when it's not being implemented? I start off by reminding everyone that it is civil society. It's the push and pressure of civil society that we have these standards spelt out as our safeguard. The United Nations started off as a club of governments. They were there to settle their disputes, but it gradually became norm-based because of civil society. My position as of High Commissioner was created not because governments woke up one day and decided they want to be more accountable for human rights protection. It happened because civil society demanded oversight over human government performance at the Vienna conference. So everywhere we go, when we see that government after government is not complying with obligations that they undertook under international law, then we say the solution is that we have to strengthen civil society organizations everywhere. This is why I'm so concerned that government after government is restricting the activities of civil society. So that would be one answer to that. We cannot have a setback because there's a push from some powerful figures. I have continually recounted, so has my successor, the current High Commissioner, that it's governments who violate human rights much more. If you take Syria, for instance, is a good example. And so I like that we have now so many more measures and mechanisms than we had before. There is no going back on many of the rights. I know it's just strange to see children being separated from their parents, but even in this case, look what happened. Civil society outrage made him pull back. So this is it. We need your voice and your action here. Thank you.
Yes. Eva?
Yes, so I agree with your point. It's inherent in the whole setup of judicial review, whether domestic or supranational, that the fact that a rule has been adopted in a democratic manner just doesn't solve the problem. In my opinion, even when there is good cause to exercise judicial restraint, which can be the case in some situations, the minimum should be to check that in the domestic process a serious human rights scrutiny has taken place. And in many cases that's just simply not the case. I was in the Belgian Parliament myself when it adopted the face covering ban, and I can attest to the absolute absence of any human rights control. And as I have been arguing in the presentation, an additional point is that when it is about restrictions on minority rights, in this process it should be verified that particular attention is paid to the minority dimension and minority voice.
Yes, do you have anything to add to?
Well, I'd like to say something about the question that has been dealt with on this side. And I'm speaking largely of East Central Africa, where we do, in some cases, have a good constitution, but we have results which were indicated there. And I think in our case, it's I didn't express myself very clearly. in my presentation that, but in our case, there is an overwhelming influence of what we call ethnicity, of tribalism, and it's very hard to make appeals if you are civil society, which is convincing to people of different tribes, because they identified their welfare with leaders from that community. So that our politics are very much about tribes rather than the values that the constitutions contain. And I also agree that there is a big responsibility upon the young people. We have vote at a very early stage, so that you don't have to be very old to have some impact on the political system. But we don't find that civil society is very active. They have lots of statements they make, but very little action is done. And the older generation, there's a kind of a clique. There isn't any real difference in policies. After elections, they make their deals, and the system is extraordinarily corrupt. So this form of corruption negates any attempt at policies, at coordination of like-minded people, because even among the youth, somehow they're mesmerized by ethnicity, by tribe, and so that has made it very difficult in a number of countries that I am familiar with, however good their constitution, in fighting this evil of what you call tribalism.
Yes, thank you, Yash. I think the quality of Q&A lies in the quality and rather than the quantity of the Q&A, and we have extremely high quality of questions and answers. So thanks to all the panelists, and I think I have to bring these sections to an end. The parallel sessions will start in around 10 minutes. Most of the parallel sessions are held in the law building, which if you go to the foyer, goes towards the books exhibition, and there you turn right, pass through the two doors, you'll be in a lift lobby, and that's the law building, and it will take you to the appropriate room. And if you have any problems, our students helpers will be around to guide you. And if you want to find out which rooms where the 29 parallel sessions are to take place, you can see it on the internet, and the whole campus is Wi-Fi link. So finally, please, I look forward to welcome and seeing you at the kickoff ceremony of the 50th anniversary of the faculty at 6:30 and the reception thereafter. So please join me in thanking all our panelists again, and thank you everyone.